This is the time set for oral argument in the state of Montana versus Wesley Smith, cause number 180187. Are counsel ready to proceed?
Yes, Your Honor.
The state's ready, Your Honor.
Ms. Smith.
Mr. Chief Justice, members of the court, counsel for the state, good morning. May it please the court, my name is Deborah Smith.
You may remove your mask while you're speaking at the podium. We can understand you better if you do.
Of course, Justice Baker, is that better?
Yes, thank you.
Thank you. May it please the court, my name is Deborah Smith and I represent the appellate Wesley Smith on appeal. Wes Smith challenges the statutorily mandated requirement that he be monitored continuously by satellite and supervised by the Department of Corrections for the rest of his life, after discharge from parole and probation and after discharge from prison. The provision is facially unconstitutional as a warrantless, unreasonable search and as cruel and unusual punishment because its surveillance is mandated regardless as a blanket policy for all offenders, regardless of circumstances, and with no individualized findings made or even permitted by the sentencing judge. A judge who in this case did not want to impose the lifetime monitoring on Mr. Smith. Montana's monitoring is accomplished by a global positioning system device physically locked onto a person's body, usually at the ankle. In reality, the device is a shackle that cannot be removed. By DOC rule, the monitor sends continuous information every 5 minutes, 24/7. And DOC is allowed to charge people up to $4,000 a year to cover the cost of the surveillance. The ankle shackle is a symbol that overtly displays a person as a criminal. It is a visible badge of past criminality, as the North Carolina State Supreme Court called it in the Grady case on remand.
Ms. Smith, excuse me, that shackle that you're describing, is there any dispute that that would be employed following the expiration of a prisoner's sentence?
I don't believe there's any dispute about that, either in the statutory language, and I don't believe the state has disputed that it would remain in place after discharge from parole and probation, although Mr. Krause will indicate if so.
Let me follow up on that question because you say in your brief, and I just want to be clear, that your argument is the statute is facially unconstitutional because it mandates lifetime satellite monitoring of people whose sentences have been fully discharged. But the provision makes the offender subject to supervision for the remainder of his life. And so his sentence isn't otherwise fully discharged, even without the monitoring or the GPS monitoring. The offenders convicted under this statute are basically sentenced to lifetime supervision. So unlike the North Carolina case, they're not being monitored after supervision has terminated. Is that correct?
Justice Baker, I read the statute differently. A sentence under the Montana Code is defined as a judicial disposition upon conviction of a criminal proceeding. Section 4B of Section 625 strips any judicial discretion from the sentencing court. It is a legislative mandate that applies regardless of any inclination by the judge with no individualized determination made. So I would say, as I did in briefing, that the lifetime monitoring applies beyond the sentence. The sentence ends upon, under the definition in the code of sentence, when the judicially imposed sentence ends, which is 100 years. The legislature did not make this offense subject to life in prison without parole. And those statutes on their own can be problematic. This court itself has struggled with the constitutionality of those statutes, the life in prison. However, I will say that this is a search regardless of whether it's cruel and unusual punishment and whether the sentence is still in effect, which I don't think under the statute it can be or not, because it is a device. We know it's a search because Grady, in the U.S. Supreme Court in Grady, said so, that this is a search. And the only question is whether the search is reasonable under all circumstances. The North Carolina Supreme Court said no. The Georgia Supreme Court said no. The South Carolina Supreme Court has said no. Now, their monitoring schemes, every state's is a little bit different. Montana's is arguably the most sweeping because there's no way for the monitoring to ever end. Unlike sex or violent offender registration, there's no way to ask for the program to end. And this is mandated surveillance that is involuntarily imposed on a person whose rights under the Montana Constitution have been fully restored. And the defendant has to pay for this, which raises practical questions, but those need not be resolved today.
So counsel, let me ask you, when you are comparing or going through precedent from other states that have held that surveillance in this fashion is unreasonable, do those states like Montana hold notification statutes as not being a penalty? In other words, Montana has recognized that our notification statutes through offender registration are not part of the penalties imposed in a criminal sentence. Do those states similarly consider notification statutes in that fashion? Do you see that just what I'm trying? Okay.
I think I understand your question, Justice McKinnon. If I don't, please interject and let me know. I believe you're asking if those states have upheld the constitutionality of any offender registration programs that may exist in those states. I have to say, I don't recall it from those opinions, whether they were compared to their own offender registration statutes, but the United States Supreme Court has upheld sex offender registration. I'm not aware of any court that has, as a general matter, struck it down. You know, these lifetime monitorings, whether it's life in prison without parole, whether it's the civil penalty of offender registration, or whether it's now, you know, the three state courts I mentioned, those decisions are from 2019 and 2018 after the U.S. Supreme Court remanding Grady. So courts are struggling with where that line is on what is a penalty versus a punishment, what is a search. This is a search, whereas sex offender registration is not. And in the Grady decision by the North Carolina Supreme Court, that court examines prior precedent more than the U.S. Supreme Court's per curiam decision in Grady does. And you know, the North Carolina court looked at, you know, the intrusion on personal privacy and liberty under the U.S. Constitution. You know, not the other three courts were decided only under the U.S. Constitution. And Montana, of course, has two added protections. We've got the fundamental right of privacy, and we've got in our Constitution that a person's full civil and political rights will be restored. And it's hard to imagine that right, those rights being affected when someone that has fully discharged their debt to society can be compelled for the rest of their life in a nursing home, in a memory care center, living with their family who's taking care of them. We're talking generally about older defendants, some elderly, even before Mr. Smith would be discharged with everything. I believe he would be in his 60s. So we are talking facially about applying a monitor, a government surveillance to people, regardless of their circumstances.
So counsel, let me try to hone in a little bit more on my concern. Anytime you look at a search, you're always evaluating it in the context of whether it's reasonable. The reasonableness for this type of search would come from the notification statutes. In other words, that's the underlying purpose for the search, is the ability to provide notification to the public of the location of these sex offenders. Is that correct?
I don't think so, Justice McKinnon. If one listens to the legislative history, which I would say is not necessary because statutory language is plain, but to the extent that the court may find it ambiguous, as Justice Baker's questions were asking, is this really part of the sentence? The legislature made clear when it enacted this statute, first in 2007, it's been amended a couple times recently since, but that they intended to watch these people for the rest of their lives. I believe that's a phrase that was used by the sponsor of the original bill. And it was not as a supplement to the sex offender registration, although I will note that our legislature did consider at the time of the enactment in 2007 of this lifetime monitoring that this court had upheld the sex offender registration in Mount. And I can't remember if
that's the case.
Pardon me?
But that's the case. I was trying to find it before argument.
Yes, it is Mount. Mount is distinguishable, though, for a few reasons. Primarily, sex offender registration is not a search. It is sharing what the court looked at in Mount, because I think it's worth looking at that a little bit, is a person's expectation of privacy after they discharge their sentence. And what this court, the U.S. Supreme Court, every court that I generally remember has looked at these and said, this court has said that there is a diminished expectation of privacy if you're a convicted sex offender, as applied to sex offender registration. The sharing of your address, a photograph, listing of criminal information from your past that is public information anyway, but that burden. So the court did take an individualized determination and say, this burden is relatively low on an offender compared to a compelling state interest in protecting the public from recidivist sex offenders. So that's the analysis in Mount. In this case, it's different. For one thing, the GPS is a search. It is slapped onto your body. This information is going to, there's practical problems. There's just by statute, I don't know if it's by rule though, only one company can issue these monitors for people in the satellite-based monitoring program in Montana. And what if a person moves to another state? Or what if someone there's complications, there's practical complications about this statute. And the DOC supervision is unusual. What are they supposed to do? It can't be revoked. This is for law enforcement purposes. The Grady Court acknowledged that, and the US Supreme Court and the 3 state Supreme Courts also have acknowledged that. This program is meant to collect information, intimate details about where this person is every 5 minutes. And then the next day, all of that gets sent to DOC under the red. And so that is a search. That is very different than filling out a form once a year, even going to an in-person meeting. This is tracking where people go, what they do. There's no evidence that was put forward to the legislature, that this type of monitoring, which was very new back then, would be effective in reducing recidivism. We know that a person has a substantial privacy interest in devices involuntarily put on their person that can't be removed. So the balancing test, the state's substantial interest, one would say, is the same. Compelling interest is the same. The state hasn't disputed that this is a strict scrutiny analysis, but the privacy interests here are much more immediate and compelling. These devices can interfere with medical procedures, they can cause their own medical problems. The statute envisions no way and this was the intent, no way for this to come off. How is that supposed to work? The cruel and unusual punishment balancing is also different. It doesn't take a wild imagination to envision the outrage that will be placed on people in their senior years still having to wear this ankle monitor.
Okay, but counsel, I guess I'm looking for a clear analysis, clear framework in order to evaluate this. So if the sentence has ended, we're not under the 8th Amendment anymore, we're cruel and unusual punishment. So now what's the cleanest way, what's the way you're advocating us under the 4th Amendment or under the 8th Amendment?
I think the court could get there either way. I do believe that the 4th Amendment route is more straightforward. Just to briefly say about the 8th, that it's written, unlike sex offender registration, violent offender registration, that's written into separate statutes as a civil scheme. This monitoring is required right in the sentencing statute. So it's an odd statute, in that way. So I think you can get there the 8th Amendment way. The 4th Amendment way, though, is I submit irrefutable that this is a search and as a blanket policy without any individualized determination, it's an unreasonable search. An illustrative example of that is—
So counsel, just before you move on to your example, so if the statute ended after the offender is subject to supervision by the department for the remainder of the offender's life, period, and we did away with the electronic monitoring, the GPS monitoring, would that address your concerns? Because then basically it's almost just a redundancy of the registration statute.
That's a good question, Justice Shea, and I don't think so. I don't think it addresses my concern. It certainly addresses the physically strapping this device onto a person's body. It addresses that. But what is this DOC supervision? After they have discharged their judicially imposed sentence, what is DOC supposed to do? The purpose of that supervision remains surveillance. And the person cannot be revoked. There's no sentence they're serving anymore. The DOC regulations don't address what that supervision would look like. And there's no way to ask to get out from underneath it. the sex offender registry already, as you said, serves that purpose. If you start putting restrictions on people, you can't go to bars, you can't go to parks, you can't live near in certain neighborhoods, then the privacy interest of the individual affected is greater and greater. And the way this statute is written, there's no sideboards on DOC discretion for this unmentioned supervision, what they're supposed to do, this is surveillance, plain and simple, to monitor people who may commit future crimes, and it punishes them for their past offenses beyond a penalty that sex offender registration is.
So counsel, are you suggesting, in response to Justice Shea's question, that the DOC can't satellite monitor prisoners while they're being supervised or after? Are you suggesting there's no reasonable basis to monitor through satellite, the ankle bracelet, without an individualized determination when that person is still a prisoner?
So I'm not making that argument, Justice McKinnon, and thank you for asking me to clarify that. So I'm only challenging the post-sentence monitoring. I will note for the court, though, in the police case that I cited from the Supreme Judicial Court of Massachusetts, that state's highest court, they struck down GPS, they eliminated during a defendant's probationary period mandatory GPS monitoring because the balancing analysis tipped in the scale of the defendant. So I think as applied challenges are hypotheticals that are not presented today to either parole searches, prison searches, probationary searches. Those are different questions, and there is there is less and less of a diminished, there's less of an expectation of privacy where from probation to parole to prison. So the highest expectation of privacy goes to people who have fully discharged their sentences and their rights have been restored.
So when you say the post-sentence monitoring, in this case, the judge sentenced him to 100 years with 80 suspended. So what's the post-sentence in that case?
Well, the post-sentence, Justice Baker, would be, so he's either in prison or on parole for 20 years, after which he's eligible. So assuming for Mr. Smith, the best case scenario, he's discharged to probation at 20 years, and I believe that he's eligible for a conditional discharge from probation. I apologize, I put it in my, but under the new sentencing statutes, I believe after 3 years, or it's a short amount of time. So someone like Mr. Smith, who was, and he was the illustrative example I was going to use. His case isn't just about him because the statute applies regardless of circumstances. But Mr. Smith is someone who maybe in his 60s is going to be discharged from even, assuming best case scenario, that he doesn't violate the terms of his conditions. And of course, if he does, he can always get put back in prison for up to 100 years. So the worst offenders, the most serious offenders, you know, the sentencing that Mr. Smith isn't challenging, right? The 100-year sentence, and currently there's a 25-year parole restriction that as of 2019, in 2017, the legislature eliminated the exception to the parole restriction that the district court found West qualified for. So, you know, so from here forward, people are going to be in prison or on parole for 25 years, and then they can, if successful, they're discharged to probation. And they can stay on probation or go back to prison for up to 100 years. They have to complete sex offender treatment. phases 1 and 2. They can be fined up to $50,000. In addition to this lifetime lifetime monitoring, this is a statute with severe penalties that Mr. Smith is not challenging, assuming he is guilty of the offense, which of course he disputes in briefing. But so this lifetime monitoring will apply, not could apply, this is a justiciable controversy, will apply to Mr. Smith and to people like him when they're old enough to have a life outside of this prison sentence. That's the way the statute's written. That's exactly what the legislature intended when it passed this statute.
So this really comes down to then it's the abrogation of the judge's discretion because you're not disputing that as a condition of probation during which, as Justice Baker pointed out, at least as it stands right now, is 80 years, that the judge could have imposed this condition. It was just that it was mandated by the statute.
Correct. This condition, I'm forgetting the way that Mr. Smith's actual conditions of probation were worded, but Mr. Smith does not challenge in this facial challenge any GPS monitoring that may be required as a condition of his probation. And then the parole board, of course, will set its own conditions. You know, the court can't rule out any possibility of a future as applied challenges. That's impossible to do. That's the role of the court to, when as applied challenges are made, to look at the law and make that balance. But that's not what the court needs to do in this case. That's not what we've asked the court to do in this case. We've simply asked the court to look at this one clause of the statute that for every person convicted where and the legislature was worried about this, you know, they said, well, what if we've got a 12-year-old victim, an 18-year-old defendant, and maybe there's some mental health challenges. Maybe there's some learning disabilities. You know, maybe this 18-year-old isn't developed as well, emotionally, mentally, as and the ordinary 18-year-old, you know. So, you know, and they were worried about, well, do those people, you know, even these young men and women, would this still apply? And the fallback, if you listen to the legislative history, which is fascinating, is the prosecutor can bring a different charge. You know, sex assault, for example. But that I agree with you 100%, Justice Shea. This statute strips any judicial discretion from not applying this to people that may not deserve it as a punishment. And regardless, it's a search. And before the state can impose a search, there has to be an individualized determination.
Counsel, let me interrupt you here for a minute. First of all, the North Carolina Supreme Court on remand from the U.S. decision in Grady recognizes in their analysis that the Fourth Amendment analysis, though it typically involves some assessment of a particularized suspicion, it doesn't necessarily require that. But so I'd like you to address that. But my main question is this, is that in the context of a facial challenge, the issue really boils down to whether or not there are no circumstances under which the statute can be applied constitutionally. And in this particular case, this is different from what the fact pattern was in the North Carolina case on remand, because this defendant is in fact on standard garden variety supervised probation for 80 years after he discharges on the 20-year prison term. So how can you say that in the context of this is an incident to or coincides and is inextricably linked to a standard probation, that this is not reasonable, and that therefore this statute can't, at least in that scenario, be applied constitutionally?
So I believe your question had two parts, Justice Sandifer, and to take the second one first, this statute is facially unconstitutional because for the same reason the statute in Yang was. Because it prohibits the sentencing judge from doing anything other than requiring this lifetime monitoring after discharge of a sentence. And related
But
to
counsel,
that,
let me interrupt you, please. Excuse me for a minute. Yang wasn't a Fourth Amendment privacy constitutional issue. So we need to not mix and match between the Fourth Amendment analysis here and the Eighth Amendment cruel and unusual punishment. And my question is focused on the Fourth Amendment privacy analysis. And I'd like you to focus on that if you can.
well, of course, Justice Sandifer, and I wasn't trying to evade your question. I apologize if it seems so. But the reason that a judge lacks any discretion, the parole board lacks any discretion, a DOC probation officer lacks any discretion to do anything other than require this lifetime monitoring, which is written as a self-executing provision. And so it's going to apply like a DNA test or sex offender registry, regardless really of whether the judge puts it in the sentencing order or not, which it gets into, and I'm not trying to get into the cruel and unusual punishment. It's just, this is such a unusual statute, both in terms of its very wide scope, the vagueness with which it applies in terms of DOC supervision. But this is, so what the US Supreme Court has said in searches, with regard to searches, is that you're right that the reasonableness standard, I believe you were saying, is less than this particularized suspicion. It's something less than a Terry stop, but there still needs to be some reason. And the court, the US Supreme Court, has said there's two categories of these tests of reasonableness. One is diminished privacy rights. What is the burden that's put on the offender? What are his rights? Now, the US Supreme Court, under Fourth Amendment law, and this court have slightly different versions of testing for warrantless searches and whether they're reasonable or not, but they're very similar. It's a totality of the circumstances where the nature and the purpose of the search is weighed against the extent to which the search intrudes on a reasonable privacy expectation. So the GPS monitoring, especially, but even continued unspecified DOC supervision that goes beyond the sex offender registry. And after a person, yes, hypothetically a person, Mr. Smith, just as an illustrative example, could be on probation for up to 80 years, which essentially is a life sentence. But it's also possible that he's going to discharge his probation early. And the shortened time frame, which I believe is 3 years, and I apologize for forgetting the actual time frame. So he has a heightened privacy interest compared to a prisoner or a parolee or a probationer. And
how is it possible for him to discharge from probation when he gets a 100-year sentence with 80 years suspended?
The 2017 sentencing statutes, Justice Sandifer, made it possible for conditional discharges, and apologize, I don't have the site, made it possible for conditional discharge of probation after a very short period of time of probation. So, and that has always been the case, right? A suspended sentence before.
But let me ask you this about that. I acknowledge that, but that's not going to happen in every case. So it's also possible that he continues to be on his base 80-year suspended portion of this. And again, when we're looking at a facial challenge, the issue is whether or not the statute can be construed in any circumstance in a constitutional fashion. And so that's my problem with that argument.
And I just to be clear, and unless the court has further questions, I'd like to reserve the balance of my time. But Mr. Smith isn't challenging any GPS monitoring condition during his probationary period. That we're not challenging that. If there's
Before you sit down, counsel, before you sit down, this is Jim Rice here. I'll ask a question, and to save time, I'll ask a two-part question in one question, so I don't have to interrupt you again. But your argument in support of a facial challenge is couched heavily in the circumstances of this case, Mr. Smith's case, and the apparent unfairness of the lifetime monitoring with regard to him, which I understand because it leads into the question of whether there should have been discretion. But for a facial challenge, you have to establish that in no circumstance, in no case, not just Mr. Smith's, but in no case would this requirement have been constitutional. And I think we can agree that there are, in fact, cases which the legislature was rightly concerned about, where you have heavily recidivist offenders who serve a prison sentence for a sex crime. They get out, they reoffend, they go back to prison, they get out, they reoffend, and they leave this trail of broken victims along the way. And I think we can agree in cases like that, it's not even arguable that this condition would be appropriate. It would be highly appropriate. And so that's part one of the question. What does that do to your legal facial challenge to the statute? And secondly, how could the legislature impose this requirement for those cases like I've just described constitutionally? Would it be simply a matter of putting a clause on the end of the statute that says, comma, subject to the determination of the sentencing court that the monitoring is appropriate? I mean, is that, in your argument, all that would be necessary to make this statute constitutional?
Thank you for those questions, Justice Rice. As to the second one first, I believe that to make this clause 4B of the statute constitutional, there would need to be an individualized determination, either or both by the sentencing court and a later body, which is what exists in North Carolina and Georgia, I believe, where there's a proceeding to determine before discharge from prison or parole what the conditions are going to be. So the legislature has options, and it's not, and what this court needs to do is decide the constitutionality of this statute as written. As to the worst offenders that you were describing in the first part of your question, I would say the mandatory sentence of 100 years is going to apply to all of people convicted under this. There's now a 25-year parole restriction that can't be waived in the situation that Wes got it waived, which was he was evaluated as a level 1 offender at low risk of reoffending. So these worst offenders, they're going to be level 3 offenders. They are not going to be the ones that succeed. The thing about this statute that makes it so cruel is that it applies to the people that are the most successful, that have been able to complete sex offender treatment, that have been able to successfully do all the rest of the things they needed to do as part of their probation in order to get their rights restored. This statute is only going to penalize people that have made it to the end, not to the worst offenders.
Thank you.
I'd like to reserve my remaining 8 seconds.
I'll give you a few more minutes than 8 seconds.
May it please the court, my name is Jonathan Kraus. I'm an assistant attorney general representing the state of Montana in this appeal. With me or with us via Zoom is Kirsten Paps, the Missoula County attorney who tried this case in the district court, and due to weather and roads, she decided it was prudent to stay home for this argument. But she is here via Zoom and zooming in. She's not a cat. Okay, so one of the main point I think that the state is going to make, and I think is dispositive in this case, was addressed very early on in Ms. Smith's argument, and that is whether the state disputes that this statute even applies in the event of completion or termination of a sentence. And the state's position is contrary to Mr. Smith's claim that, in fact, this statute plainly read does not and would not apply after termination of sentence by whatever means. In addition, the termination or completion of a sentence under this circumstance, under these 2 statutes of a 100-year sentence with lifetime supervision pursuant to that sentence, is speculative and hypothetical. And in fact, if you look at the statutes that Mr. Smith is relying on for the potential for termination of a suspended sentence in the future pursuant to the statute, and that's 46-18-208, it's legally impossible, because another statute in regard to conditional discharge of supervision, which is a prerequisite to termination of the suspended sentence, specifically makes parolees and probationers who are subject to this lifetime supervision ineligible for conditional discharge. So that path is not available.
And what statute is that you're?
Okay, the first statute is the termination of suspended sentences, 46-18-208. The other one is in the probation section, and that is 46-23-10-20 sub 3. Is the ineligible for conditional discharge.
So counsel, that gets you back to 45-5-625 and the section that we're most concerned about. I don't see how you can read 4B as not applying to a offender who has discharged their sentence.
That's not applying to. Well,
In other words, you've got an offender that has discharged their sentence, and this statute is requiring that for the remainder of that offender's life, that he or she be monitored.
okay, 625, 4A and B need to be read together and need to avoid an absurd or unconstitutional result, right? Subpart B merely is an imposition of supervision on release, just like any other supervision on release of parole or probation provision, it says for the life of the offender, in the context of 625-4A, the life of the offender will fall within, as a practical matter, the term of the total sentence. Mr. Smith doesn't challenge the 100-year term of his sentence as unlawful or unconstitutional in any way. And the two have to be read together. And also, even if the termination of suspension of sentence statute would
Well,
apply.
help me, counsel.
Sure.
Read the two together. I don't see how you get 4B constrained by 4A.
4B only applies during the period dictated by 4A. This is,
Well, I would like to see that. I think that would resolve the whole issue that is being raised.
well,
I don't see.
let's read the statute together. 4A says shall be serve a term of imprisonment of 100 years, right? You go to 4B and it says if released, that is if released from the minimum prison term, there's two options there. One is parole, or if a suspended sentence has been applied, the other option is probation. So then it says, if you're on, so in effect, if you are on probation or parole, this applies. Supervision for life. First of all, supervision is sort of redundant because supervision is going to apply in all cases, whether it's dictated or not by the statute. And participate in satellite-based monitoring for life. And I don't think the for life period can be read to create some period of time beyond the 100 years of the lawful sentence.
All right, I understand what you're saying. Can you get to the issue then that Ms. Smith raised about the individualized imposition or the individualized consideration? In other words, the judge has no discretion in applying this provision.
That's correct. In sex offense cases, the judge has no discretion in applying a lot of conditions on sex offenders. One is in this same statute where sex offender treatment is mandatory under 4A. I think it's 2 or 3. The mandatory nature of this doesn't make it unconstitutional. And one of the reasons why I think this exists in there is because obviously it's intended to be a condition of both parole and probation. And the sentencing court is not authorized to order conditions on parole typically unless authorized by the statute. So this statute says, here's a condition that's going to apply to parole that you can order in your sentence. So that's one response. The other about the mandatory nature, I think goes back to the concerns, the societal interest that Justice Rice was mentioning. The statistical and historical risk of recidivism for sex offenders as a whole. The need to protect the most vulnerable population of our citizens, children, in this case, under 12. So society and the legislature have made a determination that those who commit the sexual abuse of children under 12 years old, it's a very narrow group of offenders, are required to have the 100-year sentence as opposed to a term of years that ends much shorter, and is required to be supervised for life during that sentence.
Uh-oh, we're having some trouble with Zoom.
I think we're back.
May I take a quick break for a swig of water? Thank you. So those societal interests are there, and they're embodied in the statutory the legislative will, evident in the statute. It's not, oh, this sentence seems like a good idea. No, there's good reasons to treat sex offenders differently, and especially sex offenders who commit against the youngest victims, the most vulnerable victims. And, so that goes to both proportionality and, which I guess is the mandatory issue from Yang. But it also goes to make searches reasonable, which Mr. Smith does not challenge the reasonableness of any of these provisions while serving the sentence that he's on. He is only challenging, in effect, is making an as-applied challenge, even though it's couched facially. It's basically saying this statute is lawful during the term that it applies when you're on probation or parole for the 100 years. But it's unlawful as it's applied after that. And the state would basically agree with that. But the preferable way, instead of creating a future constitutional claim, is to simply read these statutes together in a constitutional manner that doesn't reach the absurd result of, that a valid condition of a valid sentence would apply to restrict an offender's freedom after his or her sentence ends. It doesn't make sense.
Right, so you're equating in 4B, offender's life as being the same as 100 years in 4A, therefore the sentence, it's not reaching out and touching somebody beyond the termination of their sentence. The sentence actually endures for a period of 100 years, which is essentially a life sentence.
As a practical matter.
So that does then get us into, I'd say, the Eighth Amendment issue where there is a requirement, a mandatory requirement for a sentence to be imposed, which it imposes a Fourth Amendment search for a period of life without giving the judge any discretion to decide whether that imposition is appropriate. So there are problems with equating life to 100 years under your analysis.
Well, except for the fact that Mr. Smith is not saying that during that period of time, it's either illegal or unlawful or excessive. The question is not presented here.
What he is saying, he's saying that the imposition of that type of sentence, if you can't have it both ways. It's either part of the sentence and you're trying, and the sentence then goes for 100 years without discretion of the sentencing judge, or it's not part of the sentence, and this statute reaches out beyond the period of supervision to restrain a Fourth Amendment right. It's one or the other.
Well, I don't think this can be read to apply a sentencing a condition on suspension or release after the period of suspension or release is over.
Okay.
And to the extent that
you're also just saying, I mean, did I hear you correctly that I missed the statute, but that Mr. Smith is basically going to be ineligible to ever get out from underneath like a conditional discharge? Is that what you're saying, is that he can't ever do that?
as the statute is currently written, that is correct.
And what, can you give me that statute number again?
Sure, the one that makes these offenders subject to that ineligible is 46-23-10-20-1020.
Okay, thank you.
And the statute for termination of a suspended sentence is 46-18-208. So the reality is that offenders under this statute will have either a prison sentence or supervision for 100 years, which as a practical matter is for their life. And I don't think that by saying for life means if you manage to terminate that sentence, it will continue on. In fact, some of the things that Ms. Smith addressed, talking about how absurd is this statute that would apply after the sentence is over, and pointing out that there's no way to revoke, and what would they violate? What would happen if a person? I mean, what is it looking for? I mean, that goes into the argument of reading the statutes together to avoid an unreasonable or unconstitutional result. In effect, by reading it that way and saying these words in this statute are going to make this apply after your sentences end, creates the unconstitutionality. Whereas you can read it to avoid the unconstitutionality. And in the event that the provision or any provision, any provision in any sentence, if the state or DOC or probation or parole officer said, oh, sentence is up, but I'm still going to make you do the following.
But Mr. Krause, excuse me.
Sure.
Excuse me, but the upshot of your argument seems to be that you're asking us to, frankly, creatively construe this statute with another statute to say at the bottom line that when the legislature expressly said that this is a lifetime requirement, that life doesn't really mean life. And I don't know how we can credibly do that.
I'm not sure that it's reading the statutes as they are together. And the reality is that it is an imposition of either prison, which in this case is not unconstitutional to serve the entire period in prison, or release for the remainder of the 100 years.
But a 100-year prison sentence is within the discretion of the judge. And your answer to me previously was that Smith is not challenging the period of monitoring that's required for the duration of his sentence. So I guess that's your position is then that the issue of the judge being able to discretionarily impose this condition isn't really in front of us at this point.
That is correct. And frankly, in the state's mind, neither are questions about a search or questions about generally the excessive nature of anything.
Mr. Cross, under this statute, is the 100-year sentence in the discretion of the judge?
I don't think so. I think it says shall be sentenced for 100 years. It does not say up to 100 years.
At least this aspect of the sentence.
That aspect of the sentence. And I think the second aspect of the sentence is that it recognizes if released, these conditions will apply, just like all conditions of probation might apply or parole, except that this parole condition would apply. And that may be another reason for saying for life. It's not just for probation, but it's for parole. That's part of your life too. So the other thing about arguing that the facial, I'm not sure, I think it still sounds much more like an as applied, because ending the sentence is contingent. It might happen. Mr. Smith has not discharged his sentence in any way. He will not be eligible to discharge his sentence. And that's the truth for most offenders. In fact, I'm not sure that any offenders sentenced under this are even out of prison at this point, because the statute went into effect in 2007, and typically we're talking about a longer imprisonment. I don't know that for a fact, but this is future unconstitutionality if it were to apply. The state's position is that this statute doesn't apply if the sentence ends. But the likelihood of that is very low.
So you're basically just saying, at least as we sit here today, that this just isn't a justiciable controversy.
Exactly. The other thing I'd like to say about the way it's been framed, I mean, I am just trying to understand, in fact, what Mr. Smith is saying. Mr. Smith says it only applies if the sentence ends, however that should be. We disagree with that. The state disagrees with that, and I don't think there's any reasonable interpretation of the statute that could require it to apply. However, if that were true, that it was unconstitutional because it applied at that point, it can't be a facial claim, because that means there's, as has been brought up, there's no set of circumstances where the statute would be valid. But we know from Mr. Smith's concessions that the statute is valid for the period of the sentence until it's terminated, right? And so it can't be a facial violation. It has to be a as applied challenge based on some future, and I would say very hypothetical event.
So counsel, your argument doesn't stand in the face of an as-applied challenge, because if I understand your argument correctly, 4B imposes a lifetime 100-year sentencing requirement. So that supervision, regardless of what is separately set forth in other provisions, that aspect of the sentence is a life sentence, 100 years. There's no exception to that.
Correct, and Mr. Smith says it applies during the effective term of my sentence.
Mr. Smith is disputing that
If Mr. Smith's life continues beyond the effective term of his sentence, then this statute, as applied to him, if it were to be read to apply to him, and only then, not today, only if he lives to that point and his life continues and someone in the state says, guess what? We're going to keep you on satellite-based monitoring now, even though you're 138 years old. I'm not sure we're going to get there, but I think at that point, the state is going to say, you're free to go.
We're not going to get there. Somebody might get there.
Don't give up hope. I think you understand where we're coming from.
Yes.
Yeah, we've got it.
So if there are no further questions, the state would just ask that the Corporate Jack Smith's facial challenge to section 45.5, 625.4b, and affirm his judgment of conviction for the 100-year sentence for committing sexual abuse against his 9-year-old stepdaughter. Thank you.
Mr. Smith, just a second, hold on. I'll just give you a few minutes here.
Thank you, Mr. Chief Justice.
Try to be brief.
Yes, of course.
Looks like he's giving you all of Mr. Rice's time.
I see all my time.
Well, there you go. You got 7 minutes.
Thank you, Mr. Krause. Mr. Chief Justice. Well, the state is saying that 4B, when read in tandem with 4A means that the lifetime monitoring really only applies during the 100-year mandatory sentence, and that resolves the facial challenge. I would point out, I double-checked the sentencing statutes while Mr. Krause was speaking, and while at present the conditional discharge privilege after 3 years is not available to people convicted of sex offenses, the statute still allows, and I believe it's the 4618-208, still allows suspended sentences to be completed after 2/3 of the time has been served. So this means that, the court has different ways, obviously, of saying that 4B does not apply after the 100-year sentence does resolve my facial challenge. I believe it's difficult to construe the statute like that, but if the court does that, then there's no post-sentence GPS monitoring as a facial matter.
Could you repeat what you just said? I'm sorry.
And I'm not
Just
sure
want
if
to
I
be
can,
clear
or I
on
just stated.
understanding.
I believe I said, if the court construes section 4B to only apply during the 100-year sentence, then the facial challenge that Mr. Smith has made to the post-sentence monitoring is resolved. However, even though Mr. Smith may at present not be eligible for the conditional discharge in 3 years, he's still eligible to discharge his suspended sentence after he has served 2/3 of that time. That's been the law for a long time, and most people, I don't know what the stats are, discharge their suspended sentences early. So you are dealing with people that would, even when convicted in their early 30s, such as Mr. Smith was, that could be subject, if 4B is read standalone, which is what I think it requires, those people in their very old age would be subject to this lifetime monitoring, no matter what.
But if the facial challenge is resolved under that construction, that's the end of this case, correct? Because you didn't preserve an as-applied challenge, or he didn't, I'm sorry.
Correct. So below, Mr. Smith did not preserve an as-applied challenge. An as-applied challenge could be made in the future. At the time he was ready to discharge, depending on how the court resolves this.
No, and counsel, if I'm right, that's correct, but also an extension of Mr. Krause's argument is that the legislature has, through 4A and B, imposed a supervision for at least 100 years of one aspect of the defendant's sentence. So the defendant's sentence actually endures for 100 years. That sentence, he's under supervision for 100 years, and that's imposed without any discretion on the sentencing judge's part. So that, and I think we have to get to that to get rid of the facial challenge. And my question is, you have not gone further and challenged the lack of discretion that this statute imposes with respect to that aspect of the sentence. I mean, we have to say that the supervision goes that far into the future. It's 100 years.
Justice McKinnon, I may not be understanding what you're suggesting, but if I am, I would disagree. I would urge the court not to adopt an interpretation of 4B that says, regardless of whether Mr. Smith or any defendant is able to discharge their probationary period before 100 years, then the supervision still applies. And the GPS monitoring still applies. I mean, the 4B covers both DOC supervision and the monitoring. So if the privacy interests are somewhat less in DOC, unspecified DOC supervision, we don't know what that is.
But the legislature, according to Mr. Kraus, has set forth an aspect of the sentencing for this type of offense which extends 100 years. And you haven't challenged that. Your challenge is related to the termination of a sentence. Other aspects, it isn't specific to the imposition of a 100-year requirement for this monitoring.
Let me come at it a different way, same issue in terms of discretion. Let's not talk about how you read the statute. Let's just say, does the legislature have authority to impose a mandatory 100-year sentence? And no discretion, mandatory 100 years. Is that unconstitutional?
Mr. Chief Justice, it may be. And that question, or it may be, it may not be. And there's the question of, I have not made a facial challenge to the 100-year mandatory sentence. I have challenged that I have not argued that Mr. Smith would not be able to discharge probation before the 100 years. So there's a question of a tension that the court would need to resolve between early discharge of probation and the mandatory 100-year sentence. There's a separate statute that has to be read, and I believe it's the 46-18-208 that says a person who has successfully completed 3 years can get a conditional discharge or 2/3.
Okay, so your time has expired.
Thank you, members of the court, Mr. Chief Justice. I ask you to strike 4B down as facially unconstitutional.
Thank you to both counsel. This includes the oral argument. The court will now take this matter under advisement, and we will issue an order, opinion in due course.